Many administrative law cases are based on procedural injuries. As we'll see in the causation section, procedural injuries have a relaxed standard for causation, which may make the cases easier to keep in court. Procedural injury cases arise when an agency does not comply with statutory or regulatory requirements for public participation. Generally, plaintiffs also need to show the particularized Lujan type of injury, just being injured by the failure of being able to participate is not enough. This gets us into the question of the particularized injury we see in Lujan. For example, a taxpayer who wants to sue because he doesn't like the way the government is spending his taxes will not succeed because he is in the same position as every other taxpayer. There's no particularized injury. In some cases, Congress can broaden the notion of injury to allow these non-particularized claims to still meet the standing requirements. Many environmental law cases are procedural rights cases. As we'll see in Massachusetts versus EPA, the case arises because the EPA does not follow proper procedure in responding to a petition for rulemaking. This has significant implications for the holding in Mass v. EPA and whether it is going to be upheld when there are substantive challenges to the EPA's authority to regulate greenhouse gases. Challenges to environmental impact statements are also essentially procedural injuries or perhaps informational injuries because they deal with the problem that you can't properly evaluate the environmental impact of a project to comment on it unless the environmental impact statement is correctly done. However, if the procedure does not involve the public's participation, it's more difficult to get standing. For example, in Lujan, there was a procedural violation in that the agency was required to do an interagency consultation. However, this does not involve a public right to participate, and thus, while plaintiffs wanted to see the interagency consultation done, they had no standing to demand it. Permits to dredge and fill wetlands give us a good example of a typical procedural injury. The Corps of Engineers is required to do a public hearing before issuing a specific dredge and fill permit. In the case we're looking at, the National Wildlife Federation said it was injured because there was no hearing and thus they were not allowed to comment on the permit. Now, while this is an injury on its own, the court found that they first had to show that they had Lujan standing to complain about the area that was being dredged and filled. So they're going to need the geographic nexus, whether that is a member who is fishing in the area, a landowner who owns land that will be affected by the dredge and fill permit, or someone else who has an ongoing relationship to that specific area. So only if they can show the classic Lujan standing and the geographical nexus will they be able to then complain about the procedural injury for failure to have the public hearing. There's a subset of procedural injuries we call informational injuries, where Congress or a regulation requires an agency to collect and publish information for the public. Interest groups can then get into court to challenge the agency's failure to properly make the information public. So in the Federal Election Commission case, the court required that the agency collect and publish the information because it was deemed important for voters. The plaintiffs in the FEC case did not have to show the particularized injury. In this case, that they would have some special injury differentiated from other voters who were denied information published by the FEC under these requirements. That's because Congress had said in the enabling legislation that any party that was aggrieved by a commission order could obtain judicial review of the denial. That effectively eliminates the particularized injury requirement by defining the injury as being the denial of the information to anyone. We might be able to revisit Lujan as an informational injury. The complaint was that the agency did not get a required biological opinion through an interagency consultation. The court found this did not involve the plaintiffs because it was not public participation, and thus the classics procedural injury failed on that account. However, now that we have the notion of an informational injury, you might be able to argue that the public was denied the information in the biological opinion, and thus that would create an injury that would support standing.